Well, as you know, doon sa Santiago versus COMELEC, the Supreme Court ruled that the initiative law is inadequate for the purpose of amending the Constitution. But for the purpose of enacting an ordinary law, hindi nila sinabi inadequate. So we presume it's still adequate. No? That was the Santiago versus COMELEC. During the time, ang ponente niyan si Chief Justice Davide. Then came Lambino versus COMELEC. I was the ponente there. And in the motion for recon, kasi panalo kami sa main case, nag-recon yung grupo ni Lambino. And the resolution there is denied yung motion for recon, but there was a statement that of the 15 justices, 10 issued an opinion that the initiative law is adequate to amend the Constitution. So, may issue ngayon, did that reverse the Santiago versus COMELEC? Yun ang issue ngayon. Well, some justices say it did not reverse because it's not in the main opinion. In the main opinion, which I wrote, wala namang, ang sabi ko, my position was, we do not have to disturb Santiago versus COMELEC because we can decide this without disturbing, without revisiting Santiago versus COMELEC. So ako, sabi ko, we don't have to decide whether Santiago versus COMELEC is correct because we can decide this in another way, in another issue. So that's an issue. Some say that 10 should be enough to reverse Santiago versus COMELEC. Others say, wala naman yan sa main decision. There was no statement from the court na we are reversing Santiago versus COMELEC. So it's still an open question. So that whoever wants to hold a people's initiative to amend the Constitution will have to overcome two decisions, the Santiago versus COMELEC and the Lambino versus COMELEC.